Good morning. Are you acting as a judge now? No? Good. All right. Good morning, acting judge Francis-Subbiah. Did I pronounce your name correctly? All right. How are you?
Well, thank you. And how are you?
I'm fine, thanks. You have applied for one of the vacancies in the Gauteng division.
Yes, I have.
All right. Is this your first interview?
It is my first
Oh, yeah,
interview,
it is.
Justice.
All right. You hold 3 law degrees, a BUris, LLB, and LLM.
Yes, I do, Justice Maya. I have got my LLM degree in 2003.
In what area of the law was that focused?
The focus was in regard to civil procedure, women's rights, and family law.
All right. I see you have a quite checkered career that looks a bit like mine. You've been a sales coordinator and everything else in between. I did the same. Builds character, I must say. But your legal career started in 1995 when you worked in the Department of Justice as a registrar?
Yes, Justice Maya. In fact, I think I had my first run-in with the law when I started working as a legal secretary a little bit after I finished high school.
Oh, yes.
And I was sort of moonlighting and finding work. And I studied part-time. I completed all my degrees part-time by working on a full-time basis.
All right. So that's when the bug bit.
I think the bug bit a little earlier in high school. Coming from the background that I have come from, I knew that something was to happen in our country and that I wanted to be a part of it. And the way to do that would be through human rights. And the most wonderful thing that I think happened for us as South Africans was to have this amazing constitution with a Bill of Rights. And fortunate for us, it is the supreme law of our country.
All right. You became a prosecutor in 1998, and from there you built your way up to the magistracy and lectured in between.
Yes, I have been lecturing since 1998 at Justice College. I then, of course, went on to also lecture at SAJE, and we were part of the team that assisted in getting SAJE started. So I have developed a number of different programs for SAJE, which I have done at Justice College as well. So I have done a lot of mentoring and lecturing, and I've also written a book on taxation of legal costs.
Yes, we'll chat a bit about that book a little later.
Thank you.
Which subjects did you teach at Justice College, both at Justice College and with SAJE?
Justice Maya, your question?
I'm asking which subjects you taught
Oh,
at Justice College and at SAJE as well.
Well, a number of topics. In fact, I would lecture extensively in civil law, in civil procedure, and I've also dealt with legal costs and taxation. I went on to teach or lecture to registrars of the High Court as well as clerks of the court. I was also involved in lecturing on the Equality Act and the establishment of the equality courts in the country. I also had involvement in respect of the setup of the judicial jurisdiction for the regional courts. So I've been involved in a number of different levels of lecturing, mentoring, and as well as judicial decision-making.
Yeah. And are you a SAJE instructor?
From time to time, when I have been asked, I have gone and delivered lectures. In fact, in the setup of SAJE, at some point I ran the trainer course, where I trained senior magistrates from the magistracy to conduct training themselves through SAJE. And that was a very successful process. And I think it also then gave the empowerment to others to begin training.
Yep. And you, in the midst of all that, you found time to write this book, Taxation on Legal Costs in South Africa.
Yes, and the reason for that actually came from, there used to be a request quite often from the courts in South Africa, as well as courts outside of South Africa. I'd been invited to lecture in Southwest Africa, in Lesotho, Swaziland, Botswana. And then it became quite, I realized that there was a need for this kind of training in taxation of legal costs. And that was the reason which spurred me on to say, well, it's time to put all of this information in a book which Judicial published. And I hear that it has been dubbed the Bible of taxation.
Yes.
I've heard a number of commendable remarks on the book, so I think it is serving the purpose for which I intended or wrote the book, the reason why I wrote the book.
Well, it has been cited in decisions, court decisions, not only here, but across our borders as well.
Yes, yes.
All right. How long were you a magistrate? Sorry, how long have you been a magistrate?
Yes, I was appointed, actually one refers to it as Mandela Day, on the 18th of July 2000. So that gives me 22 years.
Yeah. You've had a number of acting stints in the Gauteng division since 2016.
Yes, I have, and that has been a wonderful opportunity given to me by the Judge President.
Did you manage to produce any written judgments during those stints?
I have produced a number of written judgments from all those stints, and some interesting ones, some normal ones, run of the mill, but yes, I have.
You get a mixed bag. Any of them reported?
Justice Meyer, my judgment in regard to the Conversion Act was actually, when I wrote it, I did not think of reporting it, but when it did go to the Library Committee, they came back and said this judgment should be reported. And I said, well, yes, then, have it reported. So I'm not particularly sure that, in fact, it did get reported. I was under the assumption that it did in fact get reported, but it is cited in SAFLI, and it has been used quite widely in respect of the procedure that I set out in that particular judgment. It has been quoted in a number of legal articles, even an article appearing in the Human Rights Journal. The particular matter dealt with the unfortunate situation that emanated from our apartheid years, when people in our country, black people in our country, could not own land in urban areas. And as a result of this historical tragedy, one could call it, then the matter came before me as an eviction matter, and I looked at it more deeply, and I saw that, in fact, there are more issues to consider here. I did quite a bit of my own research, and that is perhaps one of the judgments that I took the stance to set out the historical development of the legislation that emanated in the Conversion Act, and how, in fact, one would deal with those specific rights.
You've never been overturned on appeal?
Well, so far I have not. I had, in fact, given leave to appeal in a matter that I have requested to find out what, in fact, happened to that matter. But all my investigation from the clerk of court as well as the registrars of the High Court, I don't seem to have, they have not given me any feedback, so I don't know if I've been overturned on that. But I have not been overturned on anything else that I know of.
You don't have any reserved judgments, old reserved judgments, that is?
Today, as I sit here, there's not a single reserve judgment.
Any old badly head matters?
In fact, in the magistrate court, I have a part heard matter that I'm hearing tomorrow. So yes, that's the only part heard. In respect of the High Court, I have no part heard matters. And I will be going back to ACT from Monday again.
Okay. One of the professional bodies who sent in comments on your suitability for the position raised the concern that one of the judgments to which you refer, the Roman pizza one, is they could not find it anywhere.
The ones on the Roman pizza one?
Yes.
Okay, so remember, that is a judgment I wrote in the Equality Court. I do have a copy of it here.
Oh.
But it did go on appeal, and my judgment was confirmed.
So it does exist indeed, and
Oh, for sure,
does not
without doubt. In fact, it had quite a lot of media attention here in Gauteng as well as in Durban. It was in the Sowetan newspaper as well, and the headlines read, "Pizza chain to eat humble pie." Yeah, so it exists.
now you've stirred my curiosity. What was it about, very briefly?
What it was about, it raised the issue of discrimination, and it was discrimination based on religion in regard to opening a pizza chain, where it was found that because those particular investors were non-Muslim, they were, after dealing with the company for more than a year, at the last moment, they pulled out of the commercial contract, the agreement, and they said, well, we're not going to go on further in giving you the opportunity to run a pizza franchise simply because you are non-Muslim.
And you found against them, of course.
I found that there was discrimination, and such kind of discrimination is not, shall I put it plainly, allowed in terms of the Constitution. And in that regard, even if you are a powerful commercial company, you have to adhere to the supreme nature of the Constitution.
Thank you, Acting Judge. JP Mlambo, do you have questions for the candidate?
Thank you very much, DCJ. Good morning, Ms. Subbiah. Francis-Subbiah, sorry.
Good morning, JP.
Mine is just to assist you to tell the JSC what you've done when you came to ACT in Gauteng. And I'll help you do that because you completed that spreadsheet. Let's start with criminal trials. You're a magistrate, you say, for about 22 years, am I correct?
Yes, that's correct, JP.
Have you sat in criminal trials in that period?
In regard to being a magistrate for 22 years, yes, I've done lots of criminal trials and handed out many, many judgments. In the High Court, of course, I have dealt with appeals in criminal matters. I've also sat in a full court appeal where I wrote the judgment, and the senior judge approved of it and thought it was a good judgment. Yes.
Okay. That's criminal trials, and you've sat in the agent court for a week. Is that correct? I thought it was more.
JP, it was only for a week. In fact, the newly established family courts that we're now running in the Joburg division is where I had that opportunity to sit.
I see. How did you find the tempo in the agent court?
I think because it's a new court, it was not that strenuous. I coped and managed very well.
I see. And then you had 2 weeks in special motions.
Yes.
Not the opposed motions, but the special motions.
Yes, I have. I have dealt with that. I believe that those matters were perhaps much longer, more voluminous. Some of the matters would have had more than 4,000 pages, and I've dealt with that, yes.
Well, they are called special motions for a reason, isn't it?
Absolutely.
You wrote those judgments?
I have.
And,
Whatever has been put before me, I have written those judgments.
And did you comply with the 3-month period in terms of those particular judgments from the special motions?
Yes, for sure, Judge President. I make sure that all my judgments are delivered timeously. I set myself a certain limit,
Yeah.
and I get through them. Thank you.
And you sat for 6 full weeks in opposed motions, am I correct?
Yes.
Now, do you agree with me that the opposed motions court is where you accumulate reserve judgments?
Yes, once you hear the matter, and if there are a number of issues for you to deal with, then it is likely that that is where you will acquire your reserve judgments.
Yes,
I
yes.
agree with you.
And have you ever featured in my dog box list of long outstanding judgments?
No, not at all. I don't think I've ever gone more than 2.5 months. I think it might even be less.
I see, right. And you regard your period as a magistrate and having acted and you coming back. In fact, before I get there, as an acting judge in Gauteng, when you finish acting, you send a report of your acting stint to the JP, isn't it?
Yes, I do.
And you attach judgments for the JP to read.
Yes.
I see. And that's where you get a review about how you've performed once you send that report to the JP.
Yes, I think it is an opportunity to let the JP know what you've done in that period of time.
And to raise concerns if you
And of course, to raise concerns that may have occurred during that acting stint.
I see. My last question to you is your comment. You've been a magistrate for nearly 22 years. You've lectured other judicial officers. You've written a book on something that happens almost daily in the high courts in particular. You've acted, the spreadsheet says 42 weeks. Is that what says to you, you think you can take on a full-time role as a permanent judge in Gauteng?
Yes, Judge President, I think that I feel that I am ready, and the manner in which I tested it as well, which was concern for me, was to see that I can, in fact, do a full term, and I've had opportunities to do that. Yes. And my test was if I can manage my full term, come out of it with all my judgments delivered, then I can appreciate the nature and the volume of the work that comes through the Gauteng High Courts. Okay. And I feel that at this stage I'm ready, I'm mature enough to deal with the workload, and I have the necessary competencies by acting in the High Court, and this is a wonderful opportunity to serve the public from in this particular manner.
Yeah, and your list of judgments, you've listed 54 judgments. These are all High Court judgments.
Judge President, some of them I have put in relate to the Equality Court, as well as to the Harassment Court, yes, the Domestic Violence Court as well.
In the Magistrates Court?
Yes, and I've indicated that.
Yes, I think it's about 4 of them.
Yes.
Thank you. Thank you, DCJ. No further questions.
Thank you, JP. Any questions, colleagues? Any questions from the commissioners on the virtual platform?
Yes, Honourable Deputy Chief Justice.
Yes,
Yes.
Is that Commissioner Bernard? Yeah, go ahead, please.
Yes, Commissioner Singh also asked to ask a question, but I'll go ahead. Good day, Judge, or at least, Acting Judge. If I could ask you just on your IT, I see on form, paragraph 5 of your form, you're also involved with creating for the South African chapter of the International Association of Women Judges the website, if I read correctly. So maybe just tell the Commission about your intellectual technology background or knowledge, please? Thank you.
Thank you, Commissioner. Well, I must say that I am fairly savvy with electronic media now. I type all of my own judgments. I think through my fingertips now. It's a skill that I learned a long time ago. In respect of the Women Judges website, it was a wonderful initiative that we had, but it needed to be upgraded and upskilled, and that is what I worked on. It is a website that is managed by the DOJ, so I have had the assistance of the director there to have whatever matters that I wanted to have put onto that website to be uploaded. But yes, I've completely enjoyed doing that initiative. It was something that I did not have any particular IT expertise or development of how to do these amazing things that are now done on a virtual platform, but I learned, and I upgraded all of the information that is on that website. I've also included, during my period on the Women Judges Association on the executive, I produced 16 newsletters covering all the events of the Women Judges Association during that 4-year period, and all of that has been uploaded on the website. So for me, it was a learning curve, and I learned and adjusted. Thank you,
very much.
Commissioner.
Thank you, DCJ.
Thank you, Commissioner Bernard. Commissioner Singh?
Yeah, thank you very much, Deputy Chief Justice, and good morning, Ms. Francis-Subbiah. You mentioned that you served on the Domestic Violence Court and the Equality Court. Now, what role do you see, if any, that courts could play in eradicating or reducing the scourge of gender-based violence in our society? That's my first question.
Commissioner Singh, thank you for the question. In regard to the scourge which is actually a pandemic in our country with violence against women, it is unfortunate, but my view is that more women on the bench will send a very positive message out to the public, as well as the fact that when there are more women on the bench, it will create this particular situation that will have an impact in the sense that women will see that there are women on the bench and they are concerned about their particular plight, and in that particular way, it will have an impact to improve the position of women, because women understand women's issues. And one of the issues, especially in the domestic violence courts, I think it's a wonderful initiative. It's an initiative that, in my personal view, from working in the domestic violence courts, I think the interim orders as well as the final orders that are made in these courts have a massive impact. Yes, there are some very unfortunate situations that still emanate. So my view is that more women on the judicial bench would be a positive thing in the eradication of violence against women in our country. I think you also mentioned the Equality Court. And at some point in our country, it appeared like the equality courts were deemed to be a white elephant, but a lot of more media attention on it, and the fact that the processes are made easier, it's accessible in the magistrate court. I think, once again, those particular issues that safeguard our human rights that are championed in our Constitution also has that manner of coming before our courts and to provide the proper solutions or orders that can grant relief to women in this regard.
Thank you. I think you mean women understand women issues better than us men, and I agree with you there, if that's what you mean. My second question, and the last question, is you cite in your documents that you remember the Sri Satya Sai International Organization. And it's an organization I'm very, very familiar with, knowing the humanitarian work that they do for millions of people around the world, let alone for thousands in South Africa. And I think the human values approach to this organization and its teachings, has that helped you in any way as you sit on the bench as a magistrate or as a human being to develop your thoughts on being fair-minded, etc., etc.?
Commissioner, absolutely. I align the human values program that is spread by the organization with the human rights that are entrenched in our Constitution. For example, human dignity, that is a human value. And this is something that has been recognized in our Constitution, and therefore I would say that the values also that are taught by the organization, without doubt, I think makes me or contributes to me dealing with matters in a fair manner, as fair as I can be. It also makes me conscious of the social context of the people that come before us. And administering justice in a country like ours is a huge privilege, an honor, and giving, or rather really hearing at grassroots level the issues that people, or the disputes that people have, and having a role to play in that, in assisting people to realize their rights and have their disputes resolved, is one of the most wonderful ways in which to serve, and it is something that I have learned through the values emanating from the organization. Thank you, Councillor.
And I think you would liken it to Ubuntu Voto that we refer to in our own country.
Yes, and the issue surrounding Ubuntu is actually that we are all human, and it is our humanity that makes us one.
Thank you very much, Deputy Chief Justice. Thank you.
Thank you, Commissioner Singh. Commissioner Pillay?
Thank you, DCJ. Good morning, Mr. Bia.
Good morning, Councillor.
One of the key aspects about transforming the judiciary is ensuring that we have a proper pipeline from the magistracy to the high courts, where presiding officers in the magistracy are able to act in the High Court and eventually make themselves available for appointment to the High Court. I think it's important to ensure mobility, firstly, but secondly, it's an important transformative tool to ensure that the High Court is properly reflective. Can you just tell us your experience? Are there any obstacles to people getting selected, firstly, for acting appointments? And secondly, what needs to be done in order to improve that pipeline and to ensure there's proper mobility from the magistracy to the High Court?
Thank you, Councillor, for that question. In fact, it's a very important question for us to consider. In that respect, I would say that I have noticed that acting appointments are given to magistrates as well as advocates and legal practitioners who are attorneys. That is in terms of the Gauteng division. So whenever I've acted, I've seen a widespread, and I have been very pleased to see that there are a number of magistrates have been given the opportunity to act. I think there are certain tools that are in place which are welcomed, and in this regard, I can think of Sajay offers an aspirant judges course, which you have an opportunity to apply for. So as a magistrate sitting on a bench, you are invited to apply. When you apply, you are interviewed. And from that interview, a selection is taken, and then you're given the opportunity to attend the aspirant judges course. And that is a course that is lectured or tutored by judges who are on the bench, judges coming from the High Court as well as the SCA and the Constitutional Court. And that gives you also a preparation, a ground to prepare for your acting stints. Thereafter, of course, I think it depends on the judge president who invites you to come and act. I'm not particularly sure. I would assume that once a judge president is aware of your judgments and aware of the kind of work that you can do, then you are invited. So my thinking in regard to the mobility would be that at the level of the magistracy, recommendations must be met. There are a number of competent magistrates who can do the work and will excel. In fact, we can see that there are many competent judges in the high courts as permanent judges who started off being magistrates. Thank you.
So can I just ask, it's a bit concerning that this would depend on who you know, whether or not an invitation is extended for you to act. What's the scope for a magistrate being invited to act? Is there bureaucracy involved, or does it really just boil down to who you know ultimately?
Well, I think it applies across the board by virtue of the fact that one would, to be invited to this particular interview, I had the opportunity to act. Had I not had the opportunity to act, I would not be invited here. So similarly, I would say that in the magistracy, the fact that there are those opportunities to go on those particular courses, and that you are only allowed to attend the course once you have attended a particular interview. So perhaps, I'm not sure in regard to whether automatically if you were to say, I have sat 20 years on a bench, or I've sat 10 years on a bench, automatically I should get the right to go and act in a high court. I think perhaps those are considerations that one must take into account, and if it means that we have to put a process in place, then it is something that we ought to deliberate on.
Thank you. I think it is something we ought to deliberate on. Thank you.
Commissioner Notyes?
Thank you, DCJ. It's just two questions. One, how a trial court must approach the evidence of an expert in a trial?
In my view, the manner to approach an expert evidence would be, firstly, it depends on the complexity of the matter. If you're sitting in a matter that is going to run for 10 days, and if I may take an example, perhaps a medical negligence matter, then one would have a number of experts. You could easily sit with perhaps 12, 14 experts. The best approach would be that you have joint expert reports, and that these joint experts then in fact deal with the pertinent issues that remain in dispute. Having read those reports, right, it becomes quite clear what would be the issues in dispute, and those issues in dispute then will have to be dealt with in the trial. And my view then is that is how one ought to deal with the expert reports or experts in a trial matter. Eventually, it comes to a point where you will hear the experts on those particular issues, and you will make decisions in regard to which issues that you may agree with, what you may disagree with, and what you will take as binding or important in you making your final decision in the matter.
Well, I hear, but my point was the expert has given testimony, yes, evidence before you, how do you treat that evidence? I thought you just answer, how do you treat the evidence of this expert? He has testified. Is that opinion, the opinions of that expert, the conclusion, are they binding to you as a court, or how do you deal with it?
All right, once you hear an expert on an issue, remember the expert can be cross-examined by the opposing party. And then there's a re-examination. So in regard to the problematic issues, you've already dealt with them. And yes, the court ultimately makes a decision. It's not that if, in fact, an expert comes and gives an expert opinion, and the court has to now decide whether it accepts that opinion and the reasons why it does, or whether, in fact, it rejects that opinion.
The last question. In a trial where the court is conflicted, is confronted with conflicted versions of the witnesses, the plaintiff and the defendant, and the evidence is equally balanced, is conflicting, is mutually destructive, how the court must treat that evidence, how the court must resolve that dispute.
Okay, there's two ways to look at it. One would be from the perspective of if you're dealing with an application proceedings, and when you are dealing with the trial proceedings. In an application proceedings, if it is completely conflicted, you have an option to refer the matter to hearing of evidence. If it is a trial matter, then in regard to the conflict, the court can move through different stages, and one of the stages would be to make credibility findings on those particular aspects or factors that come before the court. So that in effect is how a court may deal with a dispute of factors in a trial matter.
Thank you, Commissioner. Yes, Commissioner Marumagai.
Thank you very much, DCJ. Good morning. I'm here.
Good morning, sir.
I just want to ask you a question in relation to a case that you were involved in. You said with Judge David Antawolta, Buthelezi versus Minister of Police. You remember that case?
Yes, I do remember the matter.
I found it very interesting when I was reading it.
Yes.
Because as I understood it, it was a delictual matter, but a delictual matter. In other words, a
Unlawful arrest.
police officer was, or the state was sued for unlawful entry and all those things. Yes. It was a delictual matter, and the defense was rooted in the Criminal Procedure Act. What I want to find out from that case, because I could not understand how the search in that particular case, you found that it was unreasonable, while Section 26 of the Criminal Procedure Act clearly provides police officials, when they reasonably believe that a particular person who has information in relation to a particular crime can actually assist for them to enter the premises. And I just want you also to assist me with how you use the right to privacy and the best interest of the child to come into play. I was just confused as to the interplay between all those things in light with this section that I've just spoken about. Thank you.
Thank you, Councillor. In regard to that particular matter, what was interesting is that the plaintiff sought that he had a right to privacy, and the police had invaded his right to privacy by searching his house. And Section 25 and 26 of the Criminal Procedure Act empowers the police in specific circumstances to search without a search warrant. Now, what the interplay was, and what we found, was that yes, they did have the right to go and search by virtue of the fact that it was in the best interest of the child. The child went missing. The child was missing for more than a day, and the child was last seen at that premises, on that property. And that is what gave the police the right to go and search and look in the house. And to that extent, the plaintiff had accepted, he had agreed, yes, that he knows that he'd been told the public was out there and they were standing there and they were considering that they're going to be pretty violent if, in fact, the police does not get a chance to look into their house and see, in fact, if the child is there or not. Now, how the decision moved from that perspective, and where, in fact, we did, in terms of the delictual claim, we did grant the plaintiff a portion of his claim, was because while that search was taking place, another police officer came in there and he said, do you have a license to trade in liquor? So the idea being is that the police were only granted the right into that home by virtue of the fact to look for this missing child. And that we found as, you know, the paramountcy in the Constitution, the best interest of the child is paramount. And in that respect, yes, the police could go in and search. But in regard to this other police officer who now came and said, yes, you do run a shebeen here, but do you have the license, the liquor license? And on that portion, we found that indeed that police officer did not have a right, and he invaded the privacy of the plaintiff and therefore found for him on that portion and granted him, I think it was 30,000 or something.
Yes, it was 30,000.
Yeah.
No, thank you very much. My last question is in relation, I've seen that in the judgment that you have given us, some of them have been delivered on the same day. Were these at the magistrate court? Are there any that you delivered at the High Court on the same day? Because I always thought that there are cases really that judgment can be given there and there. You don't have to postpone the matter and say the judgment is reserved and stuff. Are there any in the High Court that you delivered on the same day? And I think it's commendable. Of course, the question of quality of the judgment and research can come into question, but I think at times that is commendable.
Thank you, Councillor.
All right.
Thank you, DCJ.
All right. It does not appear that there are any more questions for you, Acting Judge Francis-Subbiah. Oh, there is one from your JP. JP,
Thank you very much, DCJ. It's a follow-up on the questions asked by Commissioner Pillay. And yes, there is some form of a process about how we source magistrates to come to the High Court. But she made a comment that it's who you know. That's how you come to act. Did you know me when you started acting in the High Court?
No, Judge President, I had no idea who you are. I did not know you. It appears like I was recommended from the judgments I had written and the fact that I used to lecture at Sajay, and I was known from my lecturing. And then I had never met the Judge President, ever known him at all, and I was then invited to come and act.
Yeah, but you agree there should be a process.
I think it would be useful if we have a process. There would be openness and transparency, and they would give other competent magistrates and people opportunities that I have been given.
Yeah, but the current process is your leader in your court makes recommendations to the JP, and the JP requests substantiation of why are you recommending these people, right? And it happens in Gauteng. But I think the questions from Advocate Pillay is that perhaps if the process has to be improved, you are best placed to ensure that there's a process that's there that opens it up to almost everyone who has an interest in acting in the High Court.
Absolutely, I agree with you 100%, JP. And I think I'd also like to say that I have not acted in other divisions, but I've only acted in the Gauteng division. And I want to reiterate that every time I have acted, the acting judges have come from the magistracy, from the attorney's profession, as well as the advocates. And that can only be because they've been invited by the judge president.
One last question, DCJ, and it's related to this. At some stage in Johannesburg, amongst a number of members of the Johannesburg Society of Advocates, the South Gauteng High Court was called the South Gauteng Magistrates High Court because of the number of magistrates who were acting in the High Court. I'm putting that to you deliberately because you sat in special motions and you would have had silks appearing before you.
Yes.
I've had a number of feedback from magistrates, especially magistrates from the district court like you, who detected some form of, I don't know, negativity towards them from silks. What was your experience?
Well, I have never had the same experience. I've always been well received.
Yes.
And I think I found counsel from silks from all levels have treated me with the required human dignity that is accorded to a judge.
Thank you. Thank you. Thank you, DCJ.
Thank you.
All right. You are excused, ma'am. Thank you so much for presenting yourself for the interview.
Thank you, Justice Maya, and thank you for the opportunity. Thank you, councillors.